Morning, my lady.
Morning, my lady.
Morning, my lady.
May it please the court, my lady. Morning.
Morning,
Morning, my lady.
Nelly Sewa, may you please place the matter on record?
Thank you, Judge. Today is Wednesday, the 1st of November, 2023. Calling the matter of Life Esidimeni Inquest, case number I-001 of 2021. Thank you, Judge.
Thank you. I'm going to request the representatives of all the parties to request people you are sitting with to mute themselves if they are not addressing the court, please. This disturbance has been so consistent. I don't understand what is happening. Mr. Sibara, good morning.
Morning, my lady. How are you?
I'm good, thanks. And you? Are you
Good
ready?
morning. We are ready to proceed, my lady. We are ready.
Okay.
Please, the court,
Yes.
my lady. We record
see.
that.
Yes.
Sorry, my lady, I interjected the court. My apology.
I was saying, I see you have filed comprehensive haze here.
That is correct, my lady.
Does that relate to all the deceased?
My lady, we realized that the evidence leaders extensively covered all the deceased in the process of drafting our heads. We then aligned our submissions with the remainder of the deceased persons with the analysis by the evidence leaders, my lady, because they've already done a very extensive work towards that project, my lady. Okay. And just to preface our submissions, my lady, we represent Dr. Manamela, myself, and Advocate Makani, my lady. As the court has put it clearly, we filed heads of argument or submissions before your ladyship and supplementary heads of argument, which are on record, my lady, in reply to the submissions by Section 27 and the families of the 4 deceased represented by Advocate Foster. My lady, we have noted with my colleague Advocate Makani that a number of issues have been crystallized by, my lady, I see the hand of Advocate Asim, my lady, sorry.
All right, Ms. Asim.
Good morning, my lady. Good morning, Mr. Sibara. I'm very sorry to interrupt. There is a ghostly image of my father, Pius Langa, above Mr. Sibara's head, which is distracting. Okay. As wonderful as it is to see his image, it's distracting the argument.
Thank you. Please, Mr. Sibara.
My lady, I just borrowed the boardroom. I'll just shift a bit.
Please do.
Yes, please, the court, my lady. So I don't know if anyone can still see
we can't see it anymore.
Thank you, my lady. Sorry for that. I apologize. So as the court, please, my lady, I was still addressing the court that the court will note that, like we pronounced yesterday, wanted to look into our submissions. We had initially requested a long time, but however, we realized that a number of issues have been covered by the previous speakers and our seniors who presented before us. And we are going to shorten our submissions quite extensively, my lady, and most of the evidence is before you. We don't want to burden you with repetition and regurgitating what is on record, my lady. Just to preface our submissions, my lady, we are in agreement.
Just before you proceed, for sure you are aware that in your haste, there are things that are not correct here in relation to the dates.
Yes, my lady, that's correct. That's
yes,
correct.
Okay. As long as you are aware, but the evidence is on record. It's not something that I'm just saying, please be mindful, because now certain things can mislead the court.
That is correct. And we really apologize for that, my lady. We were really pressed for time.
And somewhere there is a reference of a Dr. Lombard. And my recollection of the evidence is that Dr. Lombard only gave evidence in respect of Mr. Stolz.
That is correct.
You spoke about somewhere where you discuss Mr. Danica, Jan Danica.
Yes.
Docket number 32. Reference is made there on paragraph, that is page 55.
Just docket number, my lady, just a square.
32.
32. We will look at that, my lady. We will definitely.
If you can just, yeah, page 55374, paragraph 74.
No problem, my lady. We will look at that paragraph 74.
Just a second, yeah. The mention is made there of Dr. Lombard that he didn't give, he gave evidence, but you just left the issue hanging to say you will deal with the issue at a later stage.
Oh,
but
okay.
now,
We'll check it, my lady. We'll check
okay.
it. As it please the court. My lady, I was prefacing our submissions with the following acknowledgement, my lady, of the submissions of our colleagues and the submissions in particular on page 55 to 58. 552, 58.
Yes.
Paragraph.
Are those?
Paragraph 17. That is the submissions by Mr. Pichela.
Okay.
Mali, do we agree with the?
What about this paragraph?
It is recorded as follows, my lady. It goes in line with the submissions of Advocate van Bergen with regards what was said in the matter of Goniwe and others.
Okay.
1994, volume 2, SACR 425. This is the paragraph from Mr. Pichela's submissions, my lady, which we align ourselves with this paragraph, what this court is invited to investigate.
Okay.
It is recorded as follows, my lady, with the leave of the court. I just want to, I apologize for burdening this court by reading the paragraph, but however, it will translate to what we are submitting to the court. It is recorded as follows, my lady. Whilst in inquest proceedings, the question is whether a judicial officer holding the inquest, that is your position, my lady, is of the opinion that there is evidence available which could, at a subsequent criminal trial, be held to be credible and acceptable, and which, if acceptable, could prove that the death of the deceased was brought about by an act or omission which include or amounted to the commission of a criminal offense on the part of some person or persons. So, my lady, yesterday my senior advocate Hodes correctly put a rider to that what was said in Goniwe to say that at a subsequent trial, whether the court will find beyond reasonable doubt, that there is credible and acceptable evidence. That is where we are here, my lady, before you. The evidence before this court, in our view, there's no evidence before this court which is this court can find that at a subsequent criminal proceeding or criminal trial, it would be credible and acceptable against Dr. Manamela and the termination team at the end of this inquest, my lady. And furthermore, we invite this court at the inception of our submissions that this court should find that there's no evidence which this court can pronounce against Dr. Manamela in respect of the provisions of Section 62D of the Inquest Act. We say this based on the following, my lady. My lady, the evidence before you, it was canvassed at a great length that Dr. Manamela was a member of the project termination team. Before she became a member of the project termination team, my lady, she was in charge or busy implementing a policy which is referred to as 2014-2020 Vision Plan. That policy was aimed at reducing beds at Life Esidimeni centers by 200 beds per year, per financial year. And at the time of this implementation of the policy, my lady, on top of that, when the MEC was appointed in March 2014, she then came up with an additional proposed 20% above 200 reduction of beds. However, this did not even take off, my lady, because there were a number of objections from clinicians and all other role players, my lady. That is what Dr. Manamela was busy with at the time of the reduction of beds. My lady, at all material times, Dr. Manamela was the Director of Mental Health Care. She was an employee of the department and others who were part and parcel of the termination plan. My lady, let's then move to the termination year of the Life Esidimeni contract. My lady, it is uncontested that Dr. Manamela and the directorate, they had the responsibility to place over 1,444 mental health care users who were supposed to be decanted from Life Esidimeni as a result of the termination. My lady, as it was suggested by Section 27, my lady, that Dr. Manamela ought not to have given instructions for these mental health care users to be removed from Life Esidimeni. My lady, this submission does not resonate with the termination letter. At the time, my lady, there was no longer any relationship between the department and Life Esidimeni. And as a consequence of termination of the contract, which Dr. Manamela was not part of the decision to terminate, and her team, including the directorate, entirely, my lady, they were not part of the termination. Furthermore, the court should have in mind that there's evidence of Dr. Mkachwa, my lady. We are not even blaming Dr. Mkachwa in this regard, that subsequent to the receipt of the termination letter by the department, a number of staff from Life Esidimeni started to resign because their jobs were on the line. Now, my lady, here is Dr. Manamela and the directorate caught in between. In particular, my lady, let's just put them the project team, because this was not a one-man show. They are faced with over 1,400 mental health care users, of which now Life Esidimeni is being burdened. And it's common cause that the contract is going to lapse come the 31st of March 2016. That was the initial content of the termination letter, my lady. So what is it that Dr. Manamela had to do in the circumstances? I need again, my lady, to borrow from the submissions of my senior advocate holders that we are sitting here with the benefit of hindsight. And at the time when Dr. Manamela and the termination team were faced with this quagmire, they had the interest of mental health care users at heart. That is why, my lady, that the team drafted the plan, which was called Termination of Life Esidimeni Project Plan, after they were appointed formally so by Dr. Silubano. The evidence is on record, my lady. This project team, my lady, it was not only comprised by Dr. Manamela. It is unfortunate, my lady. I need to mention this in passing, that Dr. Manamela, out of all the termination plan team members, she's the only person or individual who is called a person of interest. She is the only one singled out of the termination plan. Hence, the team was working together. My lady, this project termination plan had people from infrastructure headed by Mr. Gwebindlela. They had people from finance. It had people from emergency, from the emergency. It had chief directors from districts. It had clinicians, the likes of Professor Musa, they form part of the project termination team. Professor Maledi, I struggled to pronounce his surname. Modiak, I hope I did well now. He was part of the team. Just to mention that few, just few, Maledi. Dr. Manamela, she was, of course, a deputy project manager when Mr. Musinoki was on top of the pyramid. Maledi, we are sitting before you. Our idea here is not to blame anyone. Dr. Manamela is not saying to you the MEC should be prosecuted. Not at all. My lady, it was never anticipated by the termination team that in the event that mental health care users are placed into NGOs, mental health care users might die. That was never anticipated by the team. My lady, this inquest, my lady, gave a projection of sort of one can refer it as a 3-layer, which it then became a sort of like of a merry-go-round blame game. The court is sitting with the decision makers who took the decision to terminate. The court is sitting with the implementers. That is where we locate Dr. Manamela and the termination team. So the implementation team, they're implementers. Just to borrow from the words of Mr. Musinoki when he testified that our responsibility as the team was to implement the decision of the executive. Now again, my lady, we've got below the implementation team, we've got the NGOs who then became the recipients of mental health care users. My lady, in the board of the implementation team, there were subcommittees, my lady, which were responsible for NGOs identification team. Sorry, for NGOs identification. My lady, the NGOs identification project was the functions of the district. That is the emphasis of Dr. Manamela. Before you, my lady, the district was responsible for identifying NGOs. My lady, if I can just again refer the court to Dr. Manamela's evidence document, which we have uploaded into the case line. My lady, Dr. Manamela's evidence document is found on page 34802 to 34832. 34802, 34832. My lady, this document chronically deals with the entire participation of Dr. Manamela pre-termination, during termination, post-termination. It covers the whole spectrum, including the NGO identification team. My lady, just to show the court a bit of a picture with regard to the NGO identification team responsibility, I'll refer this court to page 51251. My lady, we will have to rotate it because it looks like it's a bit upside down. My lady, this is the communication email between Dr. Manamela. I'd like to take this court a bit of an exercise about what was happening. If the court is there, the court will advise. It's an email to the MEC, which was carbon copied to a number of. It was copied. There were a number of annexures, the attachments. Unfortunately, my lady, Dr. Manamela, could not find this attachment. However, my lady, the importance of this email is found on the bottom of the email. Evening MEC, note another example of district identifying NGOs. That is an example, my lady, of how NGOs were being identified. Again, my lady, the court will see if the court can just simply scroll down to the following page, which would be 51251 below there to 5125. The court will then see again, there's an email from Joycelyn Orit to Dr. Manamela. My lady, Joycelyn Orit, she was auditing COJ. This was confirmed by Dr. Manamela in her evidence. We just want to demonstrate, my lady, that the responsibilities of NGO licensing, auditing was in the hands of the district, not Dr. Manamela. And it has been suggested, my lady, by a number of representatives. If one, my lady, I apologize, my lady, for just reading the email, but I just want the court to grasp the content and the record to reflect same. It says on paragraph in the body of the email, attached, please find 1, written audit reports. 2, license request audit reports. Not all the NGOs are here, as I still have to conduct audits. My lady, the court will note that that email was sent to Dr. Manamela on the 5th of January 2016. On the 6th of January 2016. That was way before placement. And my lady, I am going to disturb this court again and refer this court to page 51252. This is an email, my lady, which was emailed to the MEC by Dr. Manamela. She was simply forwarding an email to the MEC, which was coming from Mr. Khanyago Pauline. My lady, let's start with the email by Dr. Manamela to the MEC. Below is how we got NGOs from districts. That is Mr. Pauline Patrolina Khanyago, my lady, my apology. My apology. Paul Trina. Oh, thank you, my lady. It's what a beautiful name. My lady, there is the message to Dr. Manamela from Paul Trina. Good day. Attached is Tshwane 2016-2017 mental health budget spreadsheet. It was supposed to have been submitted to your office yesterday. My challenge is that I submitted the copy late to be signed by our chief director, and due to other commitments, he has not signed the copy. My lady, Dr. Manamela was at pains to explain to this inquest court that the responsibility for new NGOs reside with district and chief directors, not with her. And even Tshwane, that is clearly, my lady, this is the audit which is coming from Tshwane, where it has been, where this court has been told that Dr. Manamela told people or officials not to follow the correct procedure. However, this is an apology, which is, I apologize for inconveniencing. We are trying to demonstrate to you, my lady, that checks and balances have been done by the districts before the licenses were sent to Dr. Manamela for signing. My lady, Dr. Manamela explained to this court that the signing of service level agreements, SLA, with NGOs for purposes of licensing, it was the function of the districts, not the province. The only responsibility the province does is to receive licenses and put signatures. My lady, for all intents and purposes, it would be quite unfortunate to expect Dr. Manamela as the director to crisscross the whole province, auditing NGOs on individual basis by herself. Even if, my lady, if we were to expect the districts to send all documentations to Dr. Manamela, for her to go through each and every document, my lady, that would be too much to ask. My lady, Dr. Manamela testified before you that this practice of licensing NGOs in this manner, she found it in place within the department when she was hired. It is nothing she invented. It was the practice of the department. My lady, it is worth mentioning that within the directorate, Dr. Manamela had an NGO manager. That was Miss Hannah Jacobus. And she reports directly to Dr. Manamela. And for all intents and purposes, my lady, Dr. Manamela had no reasons to doubt her subordinates. The organogram of the department was there. There were people who were below her. She was there to give directions of the department and delegates, guide.
18.11 on page 55316.
Yes,
Sorry, my lady, are we still together?
It seems like the court has frozen, Mr. Sibaro.
Yes, I was very worried. I could hear my senior advocate Van Bergen on the background.
I wasn't doing anything. It sounded like me, but I don't know where it came from.
There's a sound bite of you somewhere there.
It looks like as if a record was played at the back.
I've notified Nela Sui that the judge is frozen.
Now it appears that Mr. Sibaro is gone.
these two houses. It was at Dr. Manamela. She sent letters that we need to do quality checks. We need to make sure that mental health care users who have been transferred to NGOs are receiving quality standard of care. Maleti, I'll take this court with specific communication which Dr. Manamela had sent to the NGOs about inspections of NGOs for quality of food, quality of care to mental health care users. This again, my lady, talks to the issue of the act or mission on the part of the team. My lady, I'm going to request that, my lady, I'm not going to be very long. We will quickly wrap up this issue. Just before I forget, my lady, I refer this court to the NGOs link with the clinics. My lady, clinics provides primary health care. And that was an extension by the department that in the event of illness, conditions with mental health care users, these are the clinics which the NGOs are linked to. Then where do we locate again an act or mission on the part of the officials in view of this conduct by the department? The department makes sure that NGOs are linked with clinics. They send the team to evaluate and monitor the stay of mental health care users just relatively less than a month or two after they had left Life Esidimeni. They followed them back. Then it goes back again to the considerations which this court must have as defined by the Goniwe judgment. My lady, I will propose to go to, probably that could be our last hurdle after tea, my lady. I can see now it's almost 11 o'clock. As it please the court, my lady, I propose with the leave of the court to pause now and deal with the tail end of our submissions after tea, my lady.
All right, you seem to be having a lot. Is it, or do you want us to come back at 4:30? Or, but we can come back at quarter past, yes. Fine, 15 minutes suffices. Thank you, my lady. Yes. On that note, the court will take a tea adjournment. We will resume at 11:15. We have now reconstituted. You may proceed, Mr. Sibara.
As the court pleases, my lady. My lady, we are quite mindful, well, my lady, of time, and we will try our best to wrap up. My lady, the evidence is before you on record, my lady, that there were times where NGOs, some of the NGOs would phone directly Dr. Manamela with the shortages of food, shortage of medication, shortage of linen and blankets. My lady, that demonstrated clearly, my lady, how Dr. Manamela was close to the mental health care users. The NGO, by so doing, they had someone to go to, someone who was accessible. And what is it that Dr. Manamela did after receiving this calls? My lady, the evidence is before you. Dr. Manamela made sure that medications were organized, were available, linens were available. And that was in the best interest of mental health care use. And my lady, Dr. Manamela, she was doing that in the broader spectrum of the project termination plan. My lady, the court should not lose sight of the fact that we are dealing with an act and omission. And we go back to the very same test and honors, which already has been covered by my seniors and other speakers. My lady, there's been issues which have been canvassed that Dr. Manamela gave instructions for mental health care users to be moved from CCRC to give space. My lady, that submission, my lady, unfortunately, is not supported by evidence before you. My lady, I'll refer this court to page 34835. To that, it starts from 34835 to 34849. My lady, this is a letter which was addressed to Dr. Silubano by Dr. Manamela. My lady, this letter lays bare what was happening at CCRC post-placement and how NGOs were identified for CCRC and by who. I'll quickly, for the record purposes, my lady, and for relevancy and for synergy of our submissions, beg leave for this court to quickly highlight some of the paragraphs which talks to the heart of what happened at CCRC. My apology, my lady. My lady, the content of this letter paints a picture if one looks at page, my apology, my lady, the numbering seemed to be, okay, it just does disappear, my lady. I've got the numbering now. Page 34837. 34837. Cullinan NGOs. The court will note that it is recorded that the CEO of Cullinan, which it's before this court that it was Ms. Nyatlu, continued with discussions with NGO of her choice. My lady, the evidence is before this court that the initial NGO, which was supposed to use CCRC renovated wards, was the
Yes.
NGO.
I don't want to be interrupting you. The others were addressing the court without me interrupting them. This
Yes.
evidence is, we know for a fact that there was this Love Disables.
Yes.
Suddenly there was Siabadinga, which was arranged by Ms. Nyako.
That's correct.
Yes, we have that evidence on record. Just go straight to the point if you want to say something.
My lady, the letter clearly demonstrates to you that it was the proposal of the CEO that mental health care users without families should be moved from CCRC to renovated wards. It was not the instructions of Dr. Manamela. It's contained in the letter.
Where is that?
Just a second, my lady. Just a second, my lady, just 2 minutes. Just a second. I'll propose Mr. Makani to look at it. I'll come to it.
All right.
You just quickly check it. My lady, we then look at the submissions that there's prima facie evidence within which this court can make a finding against Dr. Manamela with regard to the offenses of culpable homicide, murder, with the principle of dolus eventualist. Then, from the submissions which we have made before you, there is no any evidence, my lady, which can be found to be credible in any future criminal proceedings which can sustain the offense of culpable homicide, murder with dolus eventualis, which is foreseeability. Was it foreseeable by Dr. Manamela and their team that mental health care users, if they were placed at NGOs, including at CCRC, my lady, the court should be mindful well that mental health care users perished even at hospitals. They passed on. At government hospitals. At CCRC, my lady, that is a government institution. Vescopis, there was one mental health care user who passed on, my lady. Unfortunately, it's a sad scene in our country. But in view of this, my lady, the evidence is before this court that even at other experienced NGOs, Museko Home, Takarani, mental health care users died from different types of conditions. It was not only limited to NGOs in the district of Pretoria, in particular Precious Angels. And the question would then come back to haunt us is that, was it foreseeable, my lady, for Dr. Manamela and their team? And they appreciate that foreseeability in their conduct, that mental health care users might die as a result of the transfer. The answer is absolutely no, my lady. That's why, my lady, we then align our submissions with the submissions of the evidence leader in their closing remarks, that in view of the totality of the above, it is our submissions, my lady, this court should make a finding in terms of section 16(3) of the Inquest Act, which it's the recording of unable to make a finding. My lady, in our view, there's no nexus between the termination, the transfer, placements, and death of mental health care users. My lady, we would like to retract the statement that it was Ms. Nyatlu who gave instructions for mental health care users to be moved from CCRC to other wards. The only issue, my lady, which is captured in this letter, the only issue which is a bone of contention, I'm referring back, my lady, to the letter which I have referred the court above. It's the happening and the licensing of, and how Siabadinga was procured by the CEO, and it was using love disciplines license. My lady, with regard to the submissions, love disciples, my lady, with regard to the submissions in our heads of argument, with regard to Dr. Lombard, my lady, Advocate Makani went back and looked back at our heads, my lady. That was clearly a typo. It was a typo, my lady, and we withdraw that submissions, my lady. It was a typo, and we really apologize, my lady, for such a typo. My lady, those are the submissions on behalf of Dr. Manamela, my lady, which I can take now. If I can just have a minute and confer with Advocate Matkani if I've left something, my lady.
Okay, thank you.
Thank you. As it pleases the court, my lady, I apologize, my lady. I just got a signal now. Our client just gave us an indication that we should refer this court to page, I think this is quite relevant, my lady, to page 34837 on case lines 34837.
This is page
34837. This was the engagements between the directorate and the CEO of Cullinan Care and Rehabilitation Center. It is recorded as follows, my lady, in this paragraph. The CEO later indicated that the hospital and the NGO have plans to transfer mental health care users that are in hospital without families to the renovated place managed by the NGO, and then admit the mental health care users from Life Esidimeni in the care of departmental staff. That is the paragraph I was looking for, my lady.
Where is it on this page?
My lady, if you can check on
under Kalinen NGO.
Yes, the third,
There's a
the
first,
the fourth
second,
paragraph,
third.
fourth paragraph from the bottom of that paragraph, fourth line above.
From the fourth line from
the bottom, where it starts with the CEO later indicated.
Okay.
Thank you, my lady. That is the paragraph which I wanted this court to capture to demystify any notion that Dr. Manamela, she's the one who gave instruction that remove people from the hospital to renovated wards. This paragraph takes care of that one, my lady. As the court pleases, my lady, those are the submissions of Dr. Manamela, my lady.
Just before you conclude, the point that I was raising, if you look at, is it now? Okay. The paragraph that you said it was a typing error where reference is made of Dr. Lombard in respect of docket number 32. If you look at paragraph 75, that is page 55374. I don't know which doctor you're referring to, but it seems you say the date, which is the 8th of August and the 8th of 2016 and 2017 seems to be confusing on the post-mortem report. This Dr. Lombard testified, and this aspect was not canvassed with the doctor during the inquest. And 74, you talk about Dr. Lombard. That's the name that you said you made a typing error. If that can just be clarified. Unless if one has to, it means one has to go to that.
Sorry, my lady, sorry, I'm sorry, I was muted. I just wanted to clarity is paragraph 74. We are noting here with the advocate Makani.
Okay. Did you get the correct page?
The court mentioned paragraph 74.
70, yeah, the paragraph that I want, in fact.
Yes.
Yes, which is left open.
Yes.
Is paragraph 77.
77?
Yeah, if you just read that, you'll see that it was left
Thank
open.
You, I see the evidence leader's hand is up, my lady, advocate lady.
Mr. Late?
Yes, my lady, the Dr. Lombard who performed the post-mortem is not the same Dr. Lombard who
Oh, yes. Yes, now I remember because I had a problem. Okay, so it's not a typing error. This is correct.
It's just a wrong reference.
Yes, thank you so much. And then, but even then, 77, it's not clarified. You just left it
77,
open. Yes.
Just a second, my lady. Let me just quickly go there. 77. I got the paragraph, but I just want to contextualize it. Yes, please, the court, my lady. I've seen the paragraph. What we seem to say in this paragraph is that, like other mental health care postmortem reports, the pathologist will perform a postmortem and thereafter provide an opinion on the cause of death and probable cause of death.
Just before, I want to read this.
Yes.
You can read it. You are saying here, you have noted that the deceased Jan Dineka, there seem not to be an opinion by Dr. Lombard.
However, I got it. Yes, I will deal with this during the inquest. I got it, my lady.
Yes. So you are saying his evidence will be covered in the body of these heads, but it is not covered.
Yes, please, the court, my lady. The starting point, I can see that, my lady. It's confusing. What we intended to convey to the court that we have noted that with regard to the deceased Jan Dineka, the postmortem was conducted by Dr. Lombard. However, the postmortem was conducted by Dr. Lombard. However, like other postmortems and other
there is no opinion. Or
there is no opinion.
Okay.
Yes, there's no opinion. Thank you, my lady.
Then the last part that, however,
this evidence will be covered. The covering part of it, my lady, was with reference to the concluding that there is no opinion, which therefore talks to the probable cause, except that which has been recorded on the postmortem report.
Yes.
But you are not giving a conclusion in the sense that you are saying the statement says something to me. You are saying, be that as it may, this evidence will be covered in the body of these heads because the doctor testified before the inquest. The last part says you are confusing the same Dr. Lombard with the other Lombard.
With the other Lombard,
yes. But that still, in your heads, it hasn't. You haven't dealt with it in your heads.
My lady, the issue of confusing the doctors has been resolved.
That issue, yes. But between the however and the because, that part, what are you saying? You are saying you will cover that in your heads, but you haven't done that.
Yes, my lady. Just a second. I can see, my lady, that this aspect was not covered in the heads, and certainly, my lady, due to the volume of work which we are exposed to, we omitted to deal with this on the heads.
I don't know how the responses will. I don't know whether you still want to deal with it, but you can grab the opportunity when other people will be replying in the others, if there will still be people.
If there's any, yes, man, we'll look at it, my lady.
All right, thank you. Thank you. Meneer Pitela.
Good morning, my lady.
Mr. Elephant, hello. Meneer Oliphant.
Yes, my lady. Yes. My lady, just for the purpose of the record, I represent Diane Noile, Ethel Mube, Dorothy Franks, Karina Morale, and Mavis Mokotsinyan. Now, as alluded to in our heads of argument,
I'm going to request you to, I don't know, you seem to be well seated, but I don't understand if we can, why your voice can come out. Just try to raise your voice so that we can hear you.
Maybe we celebrated the victory too much. The voice is gone.
No, the voice is there. I don't know what is happening. Yes, continue.
Yes, my lady, as we alluded in our head of argument.
Is it the recording? Is it the device itself, or what is happening?
Perhaps it's the device because my volume
So it
is
means
at
it's the
maximum.
position that you have taken. I don't know. Just ensure that everybody hears.
I'll try to be as loud as possible, my lady. My comments, my lady.
Yes, continue.
Yes, as we have alluded to in our heads of argument, we represent 5 people, individuals, and not the NGOs. I think that is one fact that was overlooked during these proceedings. We do not propose to represent Siabadinga, Precious Angels, Anka, Tsepong, or Takalani, but in fact, my mandate is to represent these individuals who were members of NGOs and loosely referred to in the case of Ms. Ethelyn Nube as the owner. What I've noted, my lady, is that
was it not the evidence that she was the owner? If you can deal with this aspect, does that not flow from the evidence?
My lady, there's a question of context. The evidence.
Just first answer the question. The issue of saying she is the owner, did that not come from the evidence that is before this inquest? Before you start talking parables, please.
My lady, hence I'm trying to make it clear to this court and to simplify it for the court. It is a question of law.
It's a question of?
You choose a question
I think you are breaking. You still persist on, I don't know what is happening there.
Yeah, maybe it's the device. I don't know.
Yeah, you need to check your device or take a proper position because we must all hear you in order to understand your submissions.
Can the others not hear me, my lady?
You start the right way. The next thing you just break.
My lady, I can hear him very well.
Is that so?
Yes.
Can all of you hear him? Maybe it's me alone.
No, my lady, I also can't hear Mr. Pitlela very well. He fades, he comes and fades out.
Correct. Anyone else?
I have the same issue as the court, my lady. He begins clear and then volume fades down.
We are the same as well, my lady.
Thank you. Mr. Pitlela?
I'm gonna, maybe I should leave the meeting and come back,
please
my lady, so that you can see. Yes, your ladyship, please. Apologies, my lady. I hope my audio is better now.
Continue, we'll tell you.
My lady, before the interruption, the point that I was putting across was how the evidence leaders have elected to characterize my client, Ms. Nube, as being the owner. We are going to demonstrate that it is legally untenable because it overlooks certain elementary provisions of the Non-Profit Organizations Act. If an NGO is duly registered, it will not be possible for a living person to become an owner of a company. That's a misnomer. Whether for convenient purposes, you can choose to call a person practicing alone in a company as an owner, That is how you choose to characterize it. But legally, it's not possible. They cannot own an NGO because an NGO is a legal person. It's a juristic person. It is governed by the laws which provide separate legal personality, the laws that determine
Mr.
what
Pichela,
should happen in certain circumstances.
it's not fair for me to keep on interrupting you. My question was very simple. What was the evidence? Before you tell us about all your research and all this, what was the evidence? Your argument, we hear that argument. I'm just asking, where does this come from? Perhaps they will answer for themselves. Continue, because I can see that I'm not going to get an answer. Just proceed, it's fine. Because the first premise is to check what is it that is in the evidence before we get your argument. But I understand. Let's continue. It's fine. They'll have to reply, because I asked this question. Yes.
It has never been my position that Ms. Ncube is the owner of the NGO.
What was the evidence?
The evidence, my lady, will respond to the evidence that is being led before this court. Now, if the evidence leads us to choose to characterize my client as the owner of the NGO, then that is their problem. It's not for me to come, and this is not a criminal trial where we would have to a burden or an onus to disprove.
Nobody is saying you've got a burden or an onus. But what I asked was what was the evidence? What is the evidence on record? But because we all know what we have, you may continue. They will also reply, and then we will deal with the matter as is. Continue with your argument.
As your ladyship pleases. As a matter of law, it is impossible for a natural person to own an NGO. Once an NGO has been duly registered, it acquires legal personality and therefore is able to enjoy rights and obligations in its own state. We have demonstrated that the SLA, the service level agreement, was entered into between the department and the NGO, and there is no mention in any evidence that is before court of an agreement between Ethel Ncube and the Gauteng Department of Health, wherein the Gauteng Department of Health appointed Ethel Ncube to come and look after the mental health care users. That is our point of departure. If anybody can demonstrate differently, we welcome that. The first point, my lady, that I'm going to deal with are the recent media reports that were prompted by Section 27, in which they basically went to the media and told them how they are going to argue for Dr. Manamela and former MEC Matlangwe and Ethel Ncube to be charged. Now, understanding, my lady, that maybe it's their right to do so, I wish to point out one important fact that we learned from this case. When this matter initially broke, Ms. Ncube had to be placed under witness protection because of certain utterances that were made to the effect that she caused the death of mental health care users and so on. Now, I find it quite distasteful, my lady, that when this matter is still before court, people are already running to the media and putting forward their cases there and misquoting the essence of our argument in this matter, my lady. And I think the court should look into that. Ms. Ncube was very distressed by that, because the report, when they came out, they seem to have, it came out as if it is already a decided decision of this court to say that she's going to be charged. Or maybe that's how a lay person understood it. And that is the context within which I'm addressing this issue, my lady.
Okay, I don't know about it. Okay.
It was reported, unfortunately. I've verified it as an officer of the court, and I can assure this court that this is what happened. Section 27 will be able to answer to it, and they'll be able to indicate, maybe justify why they did that. I think there is a prevailing practice.
When was that
in this
done?
Profession. I think it was on Monday or something like that.
All right, we'll
When
hear
we
what they
resumed,
say.
my lady, the day
Okay.
before we resumed. Yes. So they'll be able, maybe, my lady, to speak for themselves on this. I'm just pointing it out because it's something that's caused a lot of distress for my client.
No, I wasn't aware. All right, continue.
My lady, I understand that from the head of argument of my learned friends in this matter, that
which one?
Focus is only. No, I'm still coming to that, my lady.
Oh, okay.
I understand that Dorothy Franks, Karina Morale, and Mavis Mukosinyani have not been specifically identified as or recommended for a negative finding against them, my lady. So I'm going to proceed on the premise that that is not the position. Otherwise, I would then have to also address in respect of all of them. But our position has always been that we agree with the findings or we agree with the recommendations of the evidence leaders, although we differ in how they applied the causation, the factual and legal causation test. But ultimately, it came to the same result, and we agree with them. What we do not agree with are the recommendations made by Section 27 and also made by Ms. Foster as well for the 4 families. I don't know which organization she represents, so I'm just going to make mention of it in that manner. My lady, starting with our understanding of the head of.
I think you are back to where you are now. I think it's how you take your position. Just be careful and ensure that you position yourself the right way, please. Yes, you may continue.
With regard to what is contained in the head of argument by Ms. Foster, we looked at paragraph 6.4 on page 55339.
Page 55339. Paragraph?
Yes.
Paragraph?
6.4. 6.4, my lady. We also considered paragraph 10.5 on page 55342. We also considered paragraph 13.5 on page 55344. Which carries over to 55345. The essence of what we could extract from this argument is that Dan Noile, as the CEO of Siabadinga, knew exactly what was going on at CCRC and Siabadinga at the time of transfer. She knew that she was not prepared to receive mental health care users. And then it concludes by saying that it's clear from the outset that there was lack of food, lack of medicine, complete lack of unskilled personnel. Their degree of negligence prima facie constitutes an offense of culpable homicide. And therefore, in paragraph 10.5, as the argument goes, Diane Noile on her part, conduct amounts to an offense of culpable homicide, while the others are recommended for murder or something of that nature.
Yes.
Now, my lady, I've looked at various cases which I'm going to refer the court to.
Yes. Are they in your heads? Have they been included in your heads?
Unfortunately, my lady, when the heads were done, we were very pressed for time, and we couldn't include all the material that we had. The court is aware that one is carrying a mammoth task in this matter, being alone, not having any assistance. So it was a difficult. We were fighting to beat the deadline, basically, my lady.
All right.
But in terms of the argument and the principle,
I think the same thing. You're breaking again. I don't know.
In terms of the principle, we are going to argue, my lady. It is premised on those decided cases.
I'm going to ask that once you can't hear Mr. Pitlela, please alert the court so that he can be stopped. Yes, continue.
Yes, your ladyship, please. My lady, we don't agree with the submissions.
Come again?
Demonstrate that we don't agree with those submissions that Ms. Dadnoile is guilty of culpable homicide. In fact, nobody else in these proceedings has come to the same conclusion except for Ms. Foster. Exabudanti, my lady, we will address this issue when we deal with the relevant case law and also the applicable legal principles, because we believe that that is what is useful for this court in making a proper determination of this case.
Yes.
With regard to the argument on dolus eventualis, my lady, I'll refer the Honorable Court to the case of the Director of Public Prosecutions, Gauteng versus Pistorius.
Just a second. Versus Pistorius.
Yes.
Yes.
2015, ZASCA 204, delivered on the 3rd of December 2015.
2015,
in particular,
I didn't get the full citation. 2015 ZASA SCA.
SCA 204. 204.
204.
Yes. This is when.
And this is the date is
the 3rd of December 2015.
Okay.
This is when the state appealed against the decision of the High Court to acquit Mr. Pistorius, essentially. Yes. Now, this case, my lady, has given a proper description of dolus eventualis and how it applies. And I would submit that the court should have regard to it. I'm not going to read it. It's a very long passage. So
okay.
I'm not going to read it into. Now, my lady, having dealt with the submissions by Ms. Foster, we are now moving to the submissions by Section 27. Your ladyship would have noted on page 54879, paragraph 1.
54879.
Yes. And those are the introductory remarks. It says that most of the mental health care users who died suffered starvation, dehydration, neglect, torture, and severe violation of their human rights. And this is referenced as what is contained in the Arbitration Award, volume 400, page 22271. My lady, there was a question during the proceedings as to whether the record in the arbitration, it's we should accept it as it stands in these proceedings. Now, with reference to the issue of torture, my lady, I'm going to refer this honorable court to Section 3 of the Prevention and Combating and Torture of Persons Act 13 of 2013. That section, my lady, clearly defines what
this act is act number
13 of 2013.
It is the prevention of
combating and torture of persons act.
Okay.
Section 3 defines clearly what torture means, my lady. So I think I would not agree with the description of torture as it was given then, because it does not accord with the definition of torture in this section, my lady.
Yes.
Now, my lady, when the inquest proceedings started, there was an opening statement made by the evidence leaders. It is this opening statement, my lady, I'm going to take the court to it just now. It's actually a concise summary of facts, starting from page 6.
Page 6.
Yeah. And the part that I wanted the court to actually understand, or
Mr. Pina, what is wrong and what is right there? Do you want to address the court?
I was load shedding. I was kicked out.
Okay, please just put your, thank you.
So, my lady, in terms of this opening statement, this is the premise upon which we proceeded in this inquest. The NPA was stating that they had prima facie doubt as far as causation of the deaths in relation to the possible unlawful acts of the different role players is concerned. That is paragraph 16, my lady.
Yes.
Yes. Now, we proceed, my lady, with this inquiry in
just before you proceed, Nelly Siwe, I'm worried about how Mr. Pitlela keeps on breaking. I'm not sure whether he will be audible and we won't have problems with the record. Are you there? Nelly Siwe?
Yes, Judge, I'm here.
Can you hear Mr. Pitlela?
Yes, Judge. He seems to be audible on my side.
Oh, yeah. All right, I'll rely on the record then. But if there is anyone who can't hear Mr. Pitlela, please assist us so that we can stop him, because I'm struggling to hear him properly. All right, you may proceed, Mr. Pitlela.
I apologize, my lady.
I don't know what is wrong, because everyone has been so audible.
Yeah, load shedding is back with us. So
but I don't think it's how you have taken your position there. I don't know what's wrong, and I don't know. Continue.
My lady, we in trying to assist this court to arriving at a just decision, my lady, we are proceeding. There are certain questions that arise and which we believe are important for this court to be able to answer. The first question, which in our minds is pertinent, my lady.
I can't hear you.
The first question, my lady, which we believe is important, is the question of whether the decision to transfer the mental health care users to NGOs was lawful or not.
Yes.
Now, the reason why, my lady, becomes important to inquire as to the lawfulness of that decision, it will become apparent when one starts to engage in the process of determining causation. We submit, my lady, that what we have found here is that there were various officials at different levels that were involved in the implementation of this project. Now, that is not being denied. Most of them were called and they came and they testified as to their different roles in this matter. The question that arises, my lady, is if the decision was unlawful, then it follows that the instructions emanating from that decisions were unlawful as well. If, for argument's sake, my lady, you receive an unlawful instructions within the context of an employment relationship, there is no obligation or duty on you to follow such an instruction. In fact, we can say the opposite is true. You have an obligation to refuse to follow such an unlawful instruction. Because your failure by implementing such instruction, you cannot hide behind the fact that you were following an instruction or you were following an order. That is the law, simple and straightforward. Now, hence, we are saying it's important for this court to give an answer with regard to that question of whether the instruction, the decision to move the mental health care users to NGOs was lawful or not. The issue of ownership, I think we've already dealt with that, my lady. I simply want to refer the Honorable Court to page.
I didn't pick up anything.
Pardon, my lady?
Mr. Merritt is also, Miss Merritt is, she has a...
Yes, my lady, I agree.
Yes, I can't hear anything, Mr. Pihlele. That's why I keep on interfering. You must do something, otherwise we're not getting anywhere.
Okay, it's a difficult one because I don't know what the source of
it's not. I don't know it. As I'm saying, I don't know maybe the position that we've taken where you are. Because you are the only one. Everybody has been proceeding so well. I don't understand. And you have got a voice, I know. You might have to change where you are seated. Go for it, and then we'll stop you in case there is a problem.
Yes, your Lordship, please. My lady, I was referring the Honorable Court to page 20449.
This is with regard to, I didn't get the first part. Page?
It's with regard to, the court asked me if there is evidence that where the issue of ownership.
Okay.
Yes.
Can I get the page number?
20449.
Okay.
Your Ladyship, on the page.
I'm still getting that. Yes.
This document, my lady, was dealt with as well by Advocate Sibara. Now, on the face of it, when your Ladyship scrolls down, she will see that the document says Center Manager, says Ethel Mube, says Nursing Officer in Charge, Kate Maleta, Controlling Body, Board Members. Date of inspection 28 July 2016. My lady, this aligns with our argument, or with our submission with regard to the SLA, to say that the SLA, there is the chairperson of the board who signed, and Ms. Nube signed as a director. Now, as much as you might try and wish this evidence away, it is there, it is on record. And I honestly sympathize, my lady, with the evidence leaders in Section 27, because they proceeded on a wrong premise that Ms. Ethel Nube is the owner of the NGO. Therefore, she has got she's supposed to have done this or supposed to have done that. And therefore, because that has not been done, then it falls on her.
Where is the service level? Just a second, the service level agreement. Where is it? You have just referred to it. Just give me the page number.
I've mentioned it in the heads. I'm just going there, my lady.
Okay. So if it's in the heads, obviously you have referred me to the page, isn't it?
Yes, I've referred to the page, my lady, of the SLA. And I've also indicated also the license as well, what the license says, because that in totality, my lady, is what it tells us what the intentions of the parties were at the time of contracting, who was contracting with who, because my understanding of the PFA is you can't contract with a person, with an individual.
Okay.
That's my understanding. You can't contract with an individual. It would have been extraordinary for the Department of Health to have contracted with Ms. Nube in a personal capacity. Because for all intents and purposes, all evidence point to the NGO. Hence, my lady will see that in none of the reports, the post-mortem reports or the evidence of the experts, where reference is made to poor care or negligent care, without mentioning the NGO by name or whatever, there's never an individual who is identified. And that is
you are breaking, Mr. Pitlela. We can't continue like this. Remember, Mr. Van Belgen indicated somewhere that the evidence is not fully on record with regard to the evidence of certain witnesses. I can't remember that part of the evidence on the transcript. He mentioned something that evidence has not been captured. So I don't want situations like this, please.
Yeah, I'm gonna leave and come back again, my lady, and see if that doesn't improve.
Please do.
Yes, Your Ladyship, please. My lady, I'm logging in on the web. So now I think maybe something will improve.
But we can hear you now. Unless
Yes,
okay, you are on another device.
Yeah, I've changed my mode of logging in.
Okay, proceed.
Okay. Yes, my lady, we were on the SLA where I was saying I did refer the Honorable Court to the SLA to say this is what the SLA, this is what was intended by the parties at the beginning of this thing. The understanding between Ms. Ncube and the Gauteng Department of Health was that they are contracting with an NGO and not an individual.
Mm-hmm.
I've also referred the Honorable Court to the provisions of the Non-Profit Organizations Act. 11 portions that deal with the acquisition of juristic personality, also how decisions are to be taken, as well as issues around finances and also ownership of assets, which specifically provide that members or directors cannot own assets. The assets will remain with the NPO. There's perpetual succession. So for all intents and purposes, it begs the question of what would be the motivation for Ms. Ncube to have taken this task upon herself if there was no financial motivation in that regard. I mean, that is something that the court can have regard to in ultimately trying to decide where to put the blame. My lady, we have also referred the court to section 332, subsection 1 of the Criminal Procedure Act.
What are you tentatively saying? Because I've read your case. Are you saying that she cannot be held? In fact, there is no way in which she can be held criminally responsible as a director. Is she a director?
She's a director, my lady.
Yeah, you might have to mute while otherwise there is a lot of noise from me. Mr. Profi, I've noted you. I'll come to you. Yes, I want to understand, are you saying that she's immune from prosecution? She can't be held criminally responsible for her actions?
No, my lady.
Yes, just explain so that I can understand, because now you've referred to her from the document on page 20449 as a center manager, and you're saying the service level agreement in there she's referred to as a director.
That, my lady, is to give the court a proper context to show that
yes,
Ms. Ncube was never intended that she's taking on the responsibilities of the mental health care users in her personal capacity. It was not known. The department would not have released those people into her care as an individual. And that is what this argument now is being proposed. So I'm going to answer the question of the court in respect of whether or not she can be held criminally liable. Hence, I'm referring the Honorable Court to section 332, subsection 1 of the Criminal Procedure Act, which states, my lady, that an NPO, my lady is muted.
Finish that point, and then I think there was a hand by Mr. Profi.
Yes, my lady, section 332, subsection 1 of the Criminal Procedure Act is authority for the proposition that the NPO can be held criminally liable for acts or omissions in its capacity as a juristic person. So it doesn't follow that because we should rather point our finger at Ms. Ncube because it's impossible to hold an NGO liable. The law makes provision for it. That a juristic person or corporate body can be held criminal liable for acts and omissions that were committed by its agents or directors or members or whatever the case might be. So a preference for Ms. Mncube, I think it's something that the others who are recommending will have to answer, because they proceed on the premise that she's the owner. That's why there's repetition when Advocate Butlander SC was addressing. She was saying, we all know that she's the owner. And that is an incorrect premise, and that is where we are. We are saying it's not possible. It's legally untenable. You cannot own an NGO that is duly registered. It's not possible. If there's authority for that proposition, I've presented the act that states everything. That states when juristic personality is acquired. If she feels differently and she can produce another authority, then let it be put forward to this court. My lady, I think your ladyship was saying there was a hand or something.
Yes, thank you. You have made your point, Mr. Profi. Mr. Pitela, what should happen is when I'm addressing the court, you can just, when I speak, just mute yourself. Yes, Mr. Profi.
That was my concern, my lady, that the noise that comes from the other side, then hear what the court says because of that noise. That was my concern.
Okay, thank you. You may proceed then.
Yes, your ladyship, please. I think now I've turned off the source of the noise, my lady. My lady, this also goes to the question of piercing the corporate veil and the reference to the case of Cape Pacific that Advocate Butlander referred to. I think it was Cape Pacific Limited versus Labna controlling investments. The relevant portion, my lady, it's tried law that a registered company is a legal persona distinct from the members who compose it. Equally tried is the fact that a court will be justified in certain circumstances in disregarding a company's separate personality in order to fix liability elsewhere for what are ostensibly acts of the company. This is generally referred to as lifting of the corporate veil or piercing of the corporate veil. Now, my lady,
just a second. This is now which paragraph?
Pardon, my lady?
The paragraph that you have been reading.
In the address. Does your ladyship want to know the paragraph in the case?
No, I just want to know. I thought you were reading her heads.
No. This was raised. It's not in the heads. She raised it during her address.
Oh, okay.
Where she referred the court to this specific case. Yes. And now I'm referring to the relevant portion in that case, which confirms that once we agree, because, my lady, here we are, I'm a bit off in the middle here, because on the one hand, I don't know whether ultimately the court is going to agree with me that the NGO has a separate legal personality. Hence, my address centers around the issue of separate legal personality. But I'm also going to address, with an abundance of caution, also the question of if we were to say ultimately, no, there is no separate legal personality applicable here, then let's deal with the conduct of Ms. Mncube. So I'm a bit off in the middle. I'm trying to address both of them at the same time.
Can I have that case that I think?
Cape Pacific Ltd.
I think I took it.
Yes. Versus Labna. Lubner. Labna.
LU.
B.
LU.
B for Bravo. B.
B.
NER.
Oh, yes.
Controlling Investments Pty Ltd and others. 1995, Volume 4, SA 790 AD.
Yes, proceed.
As your ladyship pleases. Now, my lady, what we have been able to, if one draws a comparison between the arguments by Section 27 and what was previously contained in Section 332(5), is that for some reason, a director would be liable for the conduct or for the acts or omissions of a company. They have an onus, a reverse onus, to prove that they were not part of that decision that the company took, which brought about liability in this instance. Now, fortunately, the courts have found that to be unconstitutional. This section 332, subsection 5. The question, my lady, that arises from this address that you have just given. So your ladyship is still there. I can see the
Yes.
It seems like your ladyship is frozen.
Am I? Do I look like?
On my part, I don't know with the others.
I can
But as
hear
long
you.
as
I
the-
It's fine, my lady.
So the question, my lady, then that arises is it legally sound to propose that Miss Ethel Ncube is or was the owner of Precious Angels? And the answer to that question is no. It's not legally sound. It's untenable. The Act, the NPO Act, says that she cannot own. It's impossible for her to own the NGO. And if you want to propose the piercing of a corporate veil, then you need to demonstrate that she was basically abusing the separate legal personality of the company, of the non-profit organization. And that has not been done. So moving on, my lady. In our view, my lady, there are several things that are being downplayed, or the significance of which is not being clearly defined before this court. We spoke about the problems that were there at the NGOs. We spoke about shortages of medication, shortages of clothes, poor linkages to clinics and hospitals, and non-payments. We spoke about incomplete or insufficient patient information with regard to their health conditions and also their special dietary needs. We spoke about, evidence was laid about the handover process and how it was conducted, how there were no assessments done on certain patients before they were handed over to NGOs. And some were even promised that in the case of Ethel Ncube and Precious Angels, there was promised that we'll come and do assessments later. But that never happened. Now, the question is, what was the impact of these things? All these lapses that we agree that they are lapses because they should have happened. We can say, we can speak all day and say there should have been audits before there were licenses. There There should have been assessments before there were handover of patients. There should have been complete medical files. There should have been this, there should have been that. We know very well from the evidence of the experts as to how this process was supposed to have unfolded if it was done correctly. We know from the experiences of Dr. Talatala, who told us, giving Takalani as an example, saying they would run it as a pilot. They would take a patient in, see if they are adjusting to the new environment, and also to allow the NGO to check if they can be able to cope with that type of patient. If the patient is not, or if the NGO is not coping, then they bring the patient back to them. Sort of a way of just testing the waters kind of thing. And that is how we understand this process should have run properly. And that didn't happen. We accept that there's a lot. Nobody's saying that this project was run properly or it unfolded in the right manner or anything of that nature. Everybody seems to agree that this didn't happen. There was warnings from experts and warnings were ignored. But what is not being said, and which is important, is what is the impact of this on the ability of the NGO to provide proper health care on the mental health care users? Because that is the inquiry at the end. If you're going to say NGOs failed, you need to demonstrate that this is what a reasonable NGO would have done. And that is not there. Dr. Robertson has stated that they've researched, they've tried to look for that standard, and they can't find it. They couldn't find it. And now this court is called upon to come and do a post-mortem of the whole process and hold that this one is liable and this one is not liable. But the problem that I have, the biggest problem, my lady, that I have with the arguments of section or the submissions of section 27 is, if we follow their logic, then it is difficult to see how the inquiry ends with Ethel Ngube. Because if it's a question of her going back to take more patients, then the rollout wasn't in one day. All the other NGOs, all the mental health care users were not placed in one day in different NGOs. The placement was in batches. So I failed to see how in one instance we can point a finger at Ethel Ngube on her own and say, yeah, this one should not have gone back there and taken more patients. It's not helping us. It's an emotive argument that has no legal basis. And it's totally placing an unreasonable burden on Ms. Ngube as an individual or on NGOs in general. They should have. That is the test that this court is being asked to apply. Should have. There's no test of that nature, my lady. Ought to is one test. Should have is not a test to check culpability or to check negligence or to check causation. Because you are imposing duties without explaining in what respect this person has failed and what is a reasonable NGO supposed to do in the circumstances. You cannot apply a reasonable person's test by ignoring the fact that this NGO was placed in a situation where it was impossible to perform. You don't pay me, but I'm supposed to feed people. There's no argument, my lady, that says that the NGOs were paid and the directors or owners of NGOs went and took the money and used it for their own devices. That is not what is being proposed. Nobody's saying Ms. Ngube took the money and went and bought herself a nice car there and upgraded her life at the expense of the mental health care users. But somehow we have to accept that she has done this thing with the knowledge of wrongfulness that is required as the legal cause of death. That is where, my lady, I find difficulty, because we cannot apply this test in a piecemeal fashion. If the result is that everybody must be charged, then let it be so, if only to give closure to the families. But we are confident, my lady, that on beyond the reasonable doubt standards, no conviction will ever fall based on the facts of this case, because that standard is more onerous. And what this case has also demonstrated for the most part is that you need to have the right, you need to call the right people to come and answer to the conduct, not just those that seem convenient. Because now it's as if we are scapegoating these NGOs. We are saying, who can we find that is easy, who we can attach the blame upon? And hence, that is why Ms. Ethel Ncube has been mentioned in her name, despite the fact that the documents and the evidence before court refer to precious angels doing this, precious angels. But when it comes to the closing arguments, we're saying no. In fact, precious angels and Ethel Ncube are one person, as if she's a sole trader who accepted this responsibility. And that, my lady, is unjust. It's unjust because it has no legal foundation. Is your ladyship still there?
I am there, yes.
The camera is frozen on my end. Sometimes it feels like I'm talking to myself.
You are the one who's talking, I'm not talking. That's why you think I'm frozen.
That's your ladyship, please. My lady, and this is where it becomes it's most difficult, because if we this is a disaster. There is a chain of events that conspired to cause ultimately an unpalatable event at the end, which is the death of the mental health care users. We cannot start the assessment in the middle. We need to go back to the beginning, starting with the decision from the executive decision, coming down to the implementation, all the people that were involved. If we cannot find fault anywhere, but we agree that all those things together, taken cumulatively, contributed towards the end to the death of this person, we can also not discount the fact that these people had these sicknesses before they went to the NGOs. We are not nobody's proposing that this sickness was acquired at an NGO, except maybe for Ms. Macapella, where they speak about gangrene having been formed and so on. But one also has to ask the question, if we accept that the nurses came and took vitals and OTs, whatever that means, then why didn't they pick up? Why didn't they pick up that something is wrong here? Why didn't they pick up these conditions? In fact, let's go back to the death of the first person at Precious Angels. The death was reported. Why didn't somebody do something then? And this failure to have closed down the NGO at that stage of the first death, is that not a culpable event? Is that not a failure of sort? Because the duty, the oversight duty, has always fallen on government, on the Gauteng Department of Health. They outsourced their responsibilities. But even so, could it have been foreseeable that people were going to die at the NGOs? Was it even possible where the NGOs themselves warned. We hear of warning of the department by SADC and so on, but was the same consideration given to the NGOs where they warned that by taking on these people, you are placing yourself at risk. People will likely die under your care, so that they can reconcile themselves with that fact, so that they can accept that level of risk to take it on. Was that kind of thing communicated to NGOs? No, emphatically no. NGOs were thrust in deep waters. Promises were made, promises of a starter kit. We are going to give you premises. A lot has been made about the license for Precious Angels reflecting a different address, and that is proposition that she operated without a license. And we are saying that is an incorrect conclusion. Miss Precious Angels or Miss Ngube is not responsible for issuing licenses. She does not participate in that decision. She has no say in that decision. To say that she operated without a license, it's almost as if you are saying that she knew that she was unlicensed, but still went ahead and operated. Or maybe she committed fraud by operating without a license, but not going to that extent, only raising the emotive aspect of it to say she took on this mental health care users knowing that she did not have an operating license, which is false. She had a license. The license was issued at a time when she was supposed to occupy different premises. She testified to this, indicated that it became impossible because those people that had agreed, the owners of those premises that appear on the licenses, pulled out at the last minute on her and said, no, we are no longer going to give you our premises. One was about to open a school or something of that nature. It was not her fault. The department knew that she will no longer be operating at that place. Nobody has come here and said, we gave Miss Ethel Ngube or Precious Angels the mental health care patients with the belief that she's going to take them to that premises in particular. The fact of the matter is, irrespective of whether the license mentioned Timbuktu or wherever, the department would still have given her the mental health care users. They have shown this thing by even continuing to bring more people and even asking her to intervene when they were having problems. There were problems at Enka and Siabadinga where there was a mix of male and female patients. Who did they go to? Miss Ethel Ngube, please come and help us. Precious Angels, you have space there. Come take these people from us. Who's failing there? Whose duty was it? And who failed in their duty here? What is the duty of an NGO when it comes to the care of mental health care users? Bearing in mind that there are only certain categories of patients that any NGO can competently care for. Unfortunately, in this instance, we'll never know, because even a capable NGO, the circumstances were such that we will never know what a reasonable NGO would have done or what a properly resourced NGO would have done. We'll never know whether Precious Angels, if it had been given the financial resources, how they would have performed. They speak of atrocious conditions at the NGO, shocking conditions at the NGO. That document that was being referred to your ladyship by Mr. Sbarra indicates an inspection that took place there. Does the document echo the same sentiments? If it was so shocking, why didn't they detect that there's problems here? Why didn't they detect that? Why didn't they do something? Why didn't they close it down immediately? Because that narrative, my lady, is not supported by the evidence. It's just emotive words that have been thrown about. Shocking, atrocious. No, we are regurgitating concepts here, but without no shred of proof. The evidence should speak for itself. And here the evidence is telling us a different story. It's telling us that NGOs were cajoled into taking mental health care users. First, they were solicited. NGOs didn't go to the department and say, "Department, do you have openings for us? Can you squeeze us in?" The officials went and sourced the NGOs, made promises to them. "We are going, don't worry. All the time, don't worry. We will come back and reallocate this patient. Well, don't worry. We're going to offer you a starter kit. You won't even have to dip into your own funds. We're gonna be there with you all the way. Don't worry." The category of patients, they are like kids. Only they are adults, but their mental functioning is that of children. So don't worry, we are there with you. Now we are saying, no, they should not have believed that story. But that is armchair criticism. Now you are coming with the wisdom of hindsight, and you are saying, yeah, but this should not have happened. Everything, every action in hindsight, my lady, is 2020. Like Mr. Late has said, 2020 vision in hindsight. I don't know if it's Mr. Late or Advocate Pinar or who. But hindsight is always 2020. Was it reasonable for the NGOs to have believed the department when the department said, "We are going to pay you," but then failed to pay? Was there a duty on the NGOs to have then said, "No, because you are not going to pay us, we are terminating the contract, and come and take your people back"? What does that say about the directors of the NGOs and their board? That they are running this for profit? Because that is where we are missing the point. An NGO is not a business. It's not for profit. It's there to help people. And that is what these people have placed. That is what they've put forward. That is the passion that drove them to accept this responsibility. Because they want to help people. Not because they are in this thing to enrich themselves. They are in this thing to make profits. That's not the philosophy of an NGO. And that has been demonstrated to be the case in this instance. Hence, I posed the question earlier, my ladies, to say, what is the financial motivation? What is the motivation for Ms. Ncube to have placed herself in this situation? What is it? Or any of the five other persons of interest, or even any of the persons who are affiliated to NGOs? What is the motivation here? What is the financial motivation for them, if any? What is the motive? None has been demonstrated. My lady, it has been said that the imposition of criminal liability in the absence of criminal intention is an abhorrent concept, both in South African law and internationally. It is important, my lady, to never be seduced into conflating negligence and culpability, my lady. Those two tests are different. They might seem like they're the same, but they're different. The considerations are different. Unfortunately, in a case of this nature, the court is going to have regard to a lot of decided cases that deal with causation in the sense of delict. But I would submit, my lady, that it is no stretch for that test to be applied in this instance, especially if this court wants to arrive at a just result. One of the cases, my lady, that I found during my research and which I found to be most appropriate for this matter is the case of State versus Tembani. It's S versus Tembani. My lady is muted.
So, S versus?
Tembani.
Tembani.
T-E-M. Yes. T-E-M.
Yes, I got it.
B-A-N-I. 2006. It's a Supreme Court of Appeal case. 151 per Cameron J.A. Just a bit of background, my lady.
Just give me that citation, 2006 volume.
It's the one that I have is just SCA 151. I can try and get a better looking citation, my lady. If the court just
the page number is 161. Oh,
151.
Thank you, my lady. The case is cited in our heads of argument. You'll find the citation in paragraph 75 of our heads. Thank you.
Paragraph 75.
Yes, my lady.
Thank you.
Yes. Okay. Yes. Now, this case, my lady, the reason why it piqued my interest is because in some respects, it reflected the reality of the level of healthcare that can be expected in South Africa. And it poses an interesting question, my lady, because the question that it poses is, if you inflict a fatal wound on a person, that person is taken to hospital for medical treatment. Then they get to hospital, there is negligent care because doctors were supposed to do this and they didn't do it. Intervention was supposed to have been done in this manner, it was not done. Ultimately, this person dies. Now, the preceding act of inflicting a wound and the subsequent act of medical negligence, could you say that because the doctors were negligent and if this person had gone to a proper hospital, he would have been saved? Then the wound is excused, or the act of injuring at the beginning is excused or not. And this is in the context of what I was raising earlier, my lady, when I spoke about the problems that were being experienced and also about the challenges that were faced by the NGOs, and also a proper classification of these challenges. What is their impact? Giving them a proper weight so that we can then, even the pre-existing conditions, because these people, most of them came at the NGOs with health conditions. Doctor, I don't know if it was, I think it's Dr. Talatala, yes. He testified that some conditions, if left untreated, they are fatal. Now, I think it was Prof. Robertson who also said that the thing is, if you don't intervene medically, the disease itself is going to lead to death eventually. That is where it's going. That is ultimately the end. It can be high blood pressure, can be HIV, can be sugar diabetes. If left untreated, you are going to die. And even if there's treatment, the treatment is only there to delay the death, because that condition is incurable. Every incurable condition, what medicine does is just intervene and delay the inevitable. Now, this is the context. That is the wound. This is what you came in with when you came under the care of the NGOs. One, the NGOs didn't know you had those conditions, because maybe that would have told them that we cannot take this person because we can't possibly be able to treat such a condition or care for somebody who needs that kind of care. But that was not communicated. That is where the assessment issue comes in. Because that assessment is also to inform the NGOs to say, will you be able to care for this type of patient? Not just a generic category of saying profoundly, intellectually, mentally, this and that, but specifics in respect of individuals. Because there are dietary requirements that go with every person, every patient. Will you, with the stipend that you are receiving from Department of Health, will you be able to care for this person? Will you be able to feed them? Now, if we say the NGOs reconcile themselves and accepted that responsibility, we are presuming that they knew that we are taking Franz Decker, for instance, knowing very well that he's going to need to be supervised 24/7 and will be able to do that. But in most instances, no, that wasn't the case. Take the case of Miss Virginia Macapella, for instance. Even when she went, even before she went to Precious Angels, there were already arguments because people were saying, no, this one, her sister is problematic, 1, 2, 3. That evidence is on record. And was she even supposed to have been at an NGO? Because what is the impact of that? If we accept that some of these patients were never supposed to have been at NGOs to begin with, what is the impact of that in the evaluation of culpability, in the evaluation of factual causation and legal causation at the end? They were never supposed to have been there. This is something, it's an anomaly. It's an anomaly because this person was never supposed to have been released to an NGO because of their condition, because of their history, because of this, because of that. Now, the act of releasing such a person to an NGO, it is the cause with in terms of its value is the most important. Is the causa causans. Because once you eliminate that, everything else falls away. But then we are supposed to say, no, let's not dwell on that one. Let's go forward. Let's get to the end. Let's say the NGO was supposed to take this person to hospital on a particular day and they did not. Because they didn't have petrol, because they didn't have staff, they didn't have drivers. So now the fault is with the NGO. We have shielded that person who decided to release that specific person to an NGO environment. And we are now going after the person at the end, saying you were supposed to have done this. You are supposed to have refused this person to begin with. Refuse how, my lady? Refuse how? Is that a legal requirement now? You are supposed to have refused. You sign a contract, you say I'm going to render a service, and then you are supposed to have refused. Did you even know that this person is suffering from this condition? Did you even know the responsibility you are taking on? Did you even know that as an NGO? And this is where we are basically, my lady. My lady, I'm gonna quote 2 cases and then I should be done. I can come back after lunch, or we can adjourn now, or we can extend for maybe 5 minutes or so. I'm in the hands of the court. The ladyship is muted.
Mr. Pitlela, it's you who's doing this to me.
Yes, just go to those two cases and then we adjourn for lunch.
Yes, Your Ladyship, please. Your Ladyship will note with the Tambani matter, my lady, that it is one that I feel it's most suitable and informative for this court, especially in the circumstances of this inquest, which has no precedence in South African law, my lady. Especially where they refuse to hold that the medical treatment can be an intervening event. I actually agree with the submissions of Section 27, but I don't agree with how with the logic that they are advancing. That's why I was saying, my lady, if we follow their logic, if we follow their reasoning, let's follow it to the end. Let it cover everybody else. It shouldn't be that because somehow it seems like when they are supposed to lead to the natural conclusion of the argument, they allow other factors to intervene in that. Instead of saying, based on this, it is our reasoning that everybody who participated in this project should be found to have contributed to the death, they now start to pick and choose at that stage. No, let's look at Manamela, and look at Dr. Manamela, the Dani Matangu and Ethel Ngube only. But then that is what defeats the argument because it's illogical at the end and it's contradictory. My lady, there was a reference to the evidence of Mr. Nofile. Now, your ladyship will note that we were not interested in this inquest. We were limited not to...
Mr. Pitlela, I'm sorry to interrupt. I'm going to stop you here. I thought you said you were quoting the two cases. Can we deal with everything after two? There is something that I have to attend to now.
Yes, your
Please,
ladyship.
I'm going to request that you check your devices because it's making a lot of noise.
Which one, my lady? Is it from
your device end? From your side. The court will take a lunch adjournment. We will resume at 2 o'clock.
Yes, the court pleases, my lady.
Yes, the court please, my lady.
Yes, we will be convened. Mr. Is
I don't know, my lady. Let me. Leadership can tell me if.
I don't know anymore now. All right, Mr. Pichela, let's proceed.
Yes, the court, please. My lady. Before the break, I had referred your ladyship as well to the procedure that was testified to by Dr. Talatala. I'm going to give your ladyship the relevant page number. It's 44427.
You may proceed.
I'm also going to ask your ladyship also to have regard to page 44477, paragraph 10, where advocate Hasim SC refers to a document, I think it's an admission form, in her questions to Dr. Talatala, which document describes Ethel Ngube as a manager, and she did not take issue with that. In fact, it's her own words in reference to that document to say she's a manager at Precious Angels. My lady, there's also, with regard to Ms. Virginia Macapella, there was a proposition put forward by Advocate Glenda SC, where she stated that Ms. Macapella was found with food in her throat that appears to have been pushed down, which proposition, my lady, is incorrect. With reference to the post-mortem, that is on page 2616. which specifically states that there was partially digested food in a throat
Page?
and in a stomach. 2616, my lady. That is the post-mortem by Dr. Noho, which states that there was partially digested food in his throat and in his stomach. Now, anybody who knows the process of digestion is it happens in the stomach, not in the throat. So food could not have been partially digested in the throat, as opposed to the proposition that food was being shoved down the throat. There was also, with reference to Virginia Macapella, that nasal feeding was a method that was not available at Precious Angels. And those were the words used or employed by Advocate Raja Batlenda. But now, what surprises me is when she speaks now of Christopher Makova. She says that he was fed nasally and that Sister Julia had to grind food down for him to eat, and they had to feed him through the nasal cavity. So maybe that's something that can be addressed so that we know exactly what is the position. If nasal feeding was done in respect of Mr. Makova, then the statement that nasal feeding was not available at the method of nasal feeding was not available at Precious Angels is incorrect and misleading. Now, my lady,
did they talk about was Ms. Bandelenda referring to the method or the device to feed the patient?
The words
I think
that
she
I
will
captured
clarify
were,
that. Okay.
The words I captured, my lady, were that nasal feeding was a method not available at Precious Angels.
Okay.
Now, with regard to Mr. Nofile, my lady, there is reliance on his evidence with regard to his observations and also his assertions that he called Ms. Ngube, which was denied. And also in his evidence where he was saying that SASA cards were available to Ms. Ngube and there were medical records and so on, which proposition was also denied. Now, in order for this court to decide to accept the version of Mr. Nofile, obviously, it will have to discount the version of Ms. Ngube. And I don't know if any emphasis or importance can be placed on that aspect of his testimony, my lady. There was also reference to Sister Julia and Monchanja. Now, these two people did not testify in these proceedings, were not subjected to any cross-examination. Reliance, therefore, cannot be placed only on the affidavits, which remain untested.
Are you saying this affidavit should then be ignored because they are part and parcel of the record of the inquest?
My lady, I'm sounding a caution to say that if your ladyship were to have regard to this evidence, it will be an infringement of the right to a fair trial for my client, in the sense that She did not get an opportunity to challenge this evidence. And that will go with all the affidavits that have been accepted on record without people having testified. It needs to be balanced against the right to a fair trial.
Continue.
Yes, Your Ladyship pleases. My lady, there is I made reference to section 332, subsection 5 of the Criminal Procedure Act. And I stated to this court that this section, my lady, has been declared unconstitutional. The only issue I neglected to mention was the case that declared this section to be unconstitutional. And that is the case of S versus Coetzee and others. In brackets, CCT 50/95, close bracket.
50/95.
Correct, my lady. 1997, volume 4. BCLR 437.
DCLR.
Bravo Charlie Lima Romeo.
Okay. And the page number?
My lady, your
the
lady
page number?
It's 437.
Come again?
437.
537.
4, my lady. 4.
Okay, thank you. 4.
Yes, your ladyship pleases.
And it's a CC decision, eh?
Correct, my lady. Now, in our submissions, my lady, and in our delineation of the principles that are applicable to the issue of causation, the issue of culpability, the issue of... We have relied on 2 cases, my lady. I want to refer your ladyship to the relevant citations. Regarding the test for negligence, the locus classicus is Kruger versus Coetzee, 1966, volume 2, SA, page 428. And it was the appellate division. Quoted with approval, my lady, in Sea Harvest Corporation, Pty Ltd, and another versus Duncan, Duncan Dock Cold Storage Ltd, and another. It's year 2000, volume 1, all SA, at page 128.
The page number?
128, my lady.
Yes.
And the test, it reads as follows. Negligence arises if a reasonable person, A, would have foreseen the reasonable possibility of his conduct injuring another person and causing him harm. B, would have taken reasonable steps to guard against such occurrence, and C, the defendant failed to take such steps. Needless to say, my lady, I don't think there will be any difficulty in modeling this case and this principle to the facts of this inquest in order for this court to arrive at a just determination. Now, with the test for culpa, my lady, or culpa, it was stated in Mukeba, M-U-K-H-E, R-B-E-R, M-U,
N for Nelly.
M for mother,
Okay.
mother, M-U-K-H-E-I-B-E-R.
Mukeba.
Versus Rath, yes, versus Rath with a double A, R-A-A-T-H, and another. 1999, volume 3 SA, at page 1065. And that is paragraph 1077 E to F.
Which decision is this?
It's an SCA decision, my lady.
Paragraph?
Paragraph E to F on page 1077.
81077.
No, 1077, my lady.
Oh, 1077. And the paragraphs are E2?
F.
Okay.
Where it says that the test for culpa can, in light of the development of our law since Kruger and Coetzee, be stated as follows. For the purpose of liability, culpa arises if a reasonable person in the position of the defendant would have foreseen harm of the general kind that actually occurred. Roman figure 2 would have foreseen the general kind of casual sequence by which the harm occurred, and Roman figure 3 would have taken steps to guard against it, and the defendant failed to take those steps. My lady, with regard to causation, we are going to refer to the case for factual causation, my lady, International Shipping Company, Pty Ltd versus Bentley.
International
Shipping Company, CO, Shipping CO, Pty Ltd versus Bentley.
Bentley.
Yeah, the fancy car, my lady.
Okay.
1990.
1990.
Volume 1 SA.
Yes.
Page 680.
680. 860.
Yes,
860.
680. Paragraphs 47 to 50.
Which decision is this?
It's an appellate division decision, my lady.
Paragraph?
47 to 50. And here it speaks of the but-for test. I think your ladyship would have noted from our heads that we have categorized certain incidents or events or happenings as but-for events. And this is the foundation upon which we base that assessment, my lady. The causa sine qua non. Lastly, my lady, we have also relied on the case of Lee versus Minister of Correctional Services. Uh, 2013, Volume 2, SA 144, and it's the Constitutional Court decision, my lady. And this case, my lady, gave the definition for the test for causation. Following challenge from the interpretation that was accorded by the SCA, although there are several academic authorities that have written extensively on this decision, my lady, and they opine that the interpretation ultimately is not in accordance with the common law. And this case, my lady, speaks of the standards ought to have done, which we juxtaposed with should have. That's what's being proposed.
Hello? Oh, Nikita, how far are you?
Is that how we should conduct these proceedings?
Nikita, how far are you?
But this can't be right. I don't understand now. I've been...
May I proceed, my lady?
Yes, you may.
Yes, your ladyship pleases. My lady, I believe that
you were submitting something, then there was this interruption. You were saying that this interpretation is not in accordance with...
My lady, the test is ought to have done and not should have.
Oh, okay.
Yes. If your ladyship recalls at the beginning, I made the references to a standard that has been developed or that is supported by the arguments, which presupposes that Ms. Nube should have taken one patient to a hospital with a private car and so on and so forth. And our submission was that you cannot look at incidents in isolation, my lady. Everything that happened in this case is a series of events that ultimately led in a disaster. Ability is to be assigned. You cannot identify one single player, especially where there is no direct intention to kill any person. That can be attributed to any person. All those contributory factors, my lady. Hence, even the post-mortem reports, the various reports speak of contributory factors. The poor care at an NGO and CCRC led to, there was poor care, which contributed to. But unfortunately, none of the experts could be able to tell this court that this one in isolation is the decisive factor. So all those things have to be taken as the decisive cause of death. Also bearing in mind that we cannot wish away that a person came with a specific disease or condition when they were transferred or when they moved from one place to another. The experts have also spoken of factors that have been underplayed, like environmental factors. Factors such as the moving of patients in itself can actually affect them and cause some of them to relapse. The stress of being in a new environment. Those things are being underemphasized. The fact that it happened in winter and people came with no clothing, and now we hear of people dying from pneumonia and bronchitis and this. But we also know that those conditions can develop even in a normal person, in a normal environment. So there is no way that you can point out to a specific thing and say, this one is the decisive cause. If we remove this one, then the result falls away, the death falls away. And that, I think, is the position of the NPA in this matter. To say, despite all the evidence that has been led and all the arguments, what we cannot find, or what we cannot find, is ultimately on the question of causation, which is what they basically were asking this court to assist them with, is to point to a specific person and say, you are the cause of all these things. Because, like, with the submissions that were made by the other councils in respect of their clients, the fact that the decision was taken has no bearing on what ultimately the conditions were at the NGO. So it's very difficult, and I sympathize with the court in that regard, because now it's faced with the mammoth task of having to untangle all this work, this Guardian knot, my lady. However, my lady, that would conclude our submissions, unless there is something else that your ladyship would like me to address.
I don't have, Mr. Pichel. I think you have addressed your issues extensively.
Yes, your ladyship pleases.
Thank you. I don't know if Mr. Mukari is there. I haven't been seeing him. Okay. Oh, you are present, Mr. Mukari.
Yes, I've been present, my lady. Thank you very much. My lady, we are going to be brief because we filed a brief heads of argument, given the nature of the issues that we were called upon to deal with in order to assist this inquest. Our heads of arguments are uploaded on case lines at page 55717. The two issues that we dealt with are those which were raised during the course of the inquest, when there was a contention made that the decision to terminate the contract with Life Esidimeni was taken. Well, initially it was alleged that it was taken by the Premier. Later on, it was said that it was taken by the PBC, which was regarded as the Premier's Budget Council. And this necessitated that this inquest should request the attendance of former Premier David Makura and former MEC Finance Ms. Barbara Creasing, who attended the inquest and tendered their viva voce evidence. Even before they could tender that evidence, which was never controverted in any terms by Ms. Mahlangu, the objective evidence was already there in the form of documents. For instance, the inquest had been provided with the presentation that was made by Ms. Mahlangu and her department at the PBC meeting of 26 November 2014. That presentation on its own, even before one could obtain viva voce evidence from those in attendance, already was speaking for itself, that the very department which Ms. Mahlangu was heading as the executive prepared a presentation in which it informed PBC about the gradual reduction of beds. And this was considered by Ms. Mahlangu under cross-examination, that is what the presentation entailed, and that's what was communicated to the PBC. What was left for Ms. Mahlangu was simply to say that notwithstanding that was a presentation that was made that there must be a gradual reduction, PBC took a decision that there must be termination. But what we can never find, and it was never pointed out in any way by Ms. Mahlangu, is any supporting documentation which backs up this allegation that the PBC took such a decision. This could not even be corroborated by the officials that she said she attended this PBC with, such as the HOD and other senior officials. So it seemed that she was the only one who knew about this decision and nobody else. But in addition to that, there was evidence of Culture was the CEO, and his affidavit has been there, which has never been controverted in any serious terms, which also confirms the presentation or confirms in the evidentiary met and then the evidence that one can take from the presentation of 26 November 2014. That is that the department, in the meeting that it had with Life Esidimeni, spoke about the gradual reduction of beds. And the dispute that emanated between the department and Life Esidimeni was the rate of the reduction, but not the reduction itself. The reduction had already been consented to or considered by Life Esidimeni, but it was the percentages that were proposed by the department which were opposed to by Life Esidimeni. And that evidence has never been controverted. But in addition to that, there is yet another documentary evidence which support the evidence that the decision to terminate was never taken by PBC, but it was taken by the department and by actually the relevant authority who, in terms of FMA, is endowed with that authority, which is the HOD, because in terms of the Public Finance Management Act, the authority that is empowered to take decisions on procurement matters and contracts that are concluded by the department is the HOD as the accounting officer. We have seen the letter of termination. It was signed by the relevant authority, which is the HOD, and nothing in that letter indicates that you are simply acting as a tool implementing somebody's decision, but he was actually taking steps in respect of the power that falls squarely within him in terms of the law. So the sum total of it is that the decision to terminate was indeed taken by the department, which was the relevant authority then to do so, because this was a clearly procurement matter. The other issue, which is also significant to support this conclusion, is the decision to take the patients to NGOs. Ms. Mahlangu confirmed in evidence, and that was under cross-examination, that the decision to take the mental health care users to NGOs was taken by her own department, and that this decision was never even communicated to PBC. And one would understand why that decision was never even communicated to PBC, because PBC has nothing to do with such decisions of procurement and termination of contracts or where patients ought to be taken to. That is a power that lies entirely within the department itself and the relevant authority of it being the accounting officer. So the evidence that has been tendered, supported by the documentary evidence, emphatically point to only one direction, which cannot be controverted, and that is the department took the decision to terminate Life Esidimeni, and it took the decision to transfer the patients to NGOs. And as to what happens thereafter is a matter that has been fully canvassed in this inquest by other relevant role players for which we have no role to play ourselves. And that concludes our submissions, my lady.
Thank you very much. Thank you.
As a court, please.
Thank you. What is the time now? If I may find out, are there any council who want to do their replies? But I think we'll deal with the replies as scheduled from tomorrow. I'm going to ask the evidence leaders and the other parties to deal with whoever wants to deal with the issues raised by Mr. Pikela in relation to criminal responsibility of Ms. Mube in her personal capacity. I know that Section 27 will deal with that, and also Ms. Foster, but I would like also the others who want to deal with that to deal with it. Mr. Martin, I saw your hand is up.
Thank you, my lady. My lady, when we first dealt with these dates, there were some days that I mentioned where both myself and Mr. Watt Pringle are unavailable, and that would be tomorrow and the day afterwards. As it presently stands, I don't have anything that I need to submit in reply.
So you're not available from tomorrow?
From tomorrow and on Friday, I will not be available. My attorneys will be watching, but I don't foresee at this point any reply from
They
Dr.
will
Silva.
indicate if there is anything.
Yes, they will indicate to me, and I will try and make a plan to come into the hearing if needs be.
Okay.
As it
Thank you
pleases.
very much. Anything that anybody wants to address the court on now? If there is nothing, I think we will resume tomorrow. Oh, Ms. Asim?
My lady, I was hoping that we could get an indication of how many replies there would be.
That is why I asked the question, so that I can have a sense, but everybody's quiet. But I'm thinking that perhaps let's give them a chance and see what happens tomorrow, because some would say they were still listening to other counsel. I don't know.
Well, maybe they could say now, so that we do have a sense.
I see.
And then, my lady, may I just request that I will do a short reply.
Yes.
But may I please go last?
Oh, okay. Because of. And Miss Foster, are you there? Perhaps the two of you can come at the end. Is Miss Foster present? So it means she's not there. Yes, I see there is a hand. Before I have noted your hand, it's fine. I just wanted to find out if there is anybody. I thought Miss Foster was present, because I think she has also to reply to certain things here. Doesn't look like she's present. All right, go ahead, Mr. Profi.
I was merely putting my hand up to indicate that I would be replying.
Is there any other person who wants to, any other party who wants to, who has an intention of replying, Mr. Pikela? So it's Ms. Hasim, Mr. Pikela, and Mr. Profi. Are they the only ones? The evidence leaders are quiet. Mr. Pinar, would you also want to reply?
May it please the court, my lady, I'm still in the process of reconsidering the situation. May it please the court, my lady.
As the court, please, my lady. Also for Dr. Manamela, we will indicate tomorrow if we will be replying or not.
Yes, Mr. Mr. Late? I'm not expecting you to reply now. I just wanted to find out who would want to reply. And hence, I've also indicated that if you can, please deal with those issues that I questioned Mr. Pikela about. And maybe you might be having other things to deal with, I don't know. Because remember, I didn't have the benefit of having your reply, but you indicated at that stage that you were not going to reply.
My lady, I see you are frozen on the screen.
Am I frozen?
No,
not on my side, Mom.
Not on the side.
Not to us, my lady.
Can you hear me, my lady?
Yes, I can hear you.
I cannot hear you, my lady.
You can hear me. I can hear you. You can still not hear me. Perhaps there's something wrong from your side.
Mr. Late, I think we can all hear Mr. Late. Maybe you must.
Mr. Late, you might
Thank
need
you.
to exit.
My lady, I had some problems with my computer's sound system, but it's working now again.
Okay, can you hear me?
Yes, I can hear you, my lady.
Okay.
Okay, there are just two aspects that I would like to reply to. Just very shortly, they actually already been addressed by some of the people, but I just want to refer reply to the arguments on behalf of Section 27 and those of Mr. Profi.
Do you want to deal with them now, or can't you deal with them in the morning tomorrow?
It's just short, my lady. It will take not longer than 5 minutes.
All right.
Okay. It's only the address regarding other offences. I just want to reiterate that it's not this court's duty to make a finding regarding any other possible criminal act than the acts that caused the death of the deceased. This is not a preliminary examination as provided for by the Criminal Procedure Act. This is an inquest. This court is not required to identify any possible crimes in terms of the Mental Health Care Act or any other act that deals with the care of mental or health care users. Even if the court found that there was a break in the continuous care of medical health care users, but the evidence is insufficient to causally link the break of the care to the cause of the death of the deceased, no positive finding can be made in terms of Section 16(2)(d) of the Inquest Act. As far as the status of the arbitration record is concerned, my lady, the Criminal Procedure Act is very clear. The acceptance thereof merely prove the correctness of the recording of that proceeding or those proceedings. It doesn't prove the correctness or the truthfulness of the contents of the evidence that was delivered at the arbitration hearing. Only that it was recorded correctly. Those are the only aspects that I want to reply on, my lady.
Okay, thank you.
Thank you.
I've requested that you also, I think, address the issue, but perhaps you can deal with that tomorrow. The issues raised by Mr. Pikela.
Which specific issues, my lady?
Well, you have dealt with the. You are still maintaining your stance in relation to the positive finding in respect of Section 16(2)(d) of the of the Inquest Act. But Mr. Pikela raised an issue that the issue in relation to criminal liability, insofar as it pertains to the NGOs, cannot be imputed to Ms. Ngube in her personal capacity. So he quoted.
I think that's what I also said in my heads of argument, my lady.
Did you?
Yes, I said even if some of the personnel of the NGO was negligent, precarious liability doesn't. Vicarious liability
it doesn't apply.
Doesn't form part of our criminal law.
Okay.
I did address that in my heads of argument.
Because he also mentioned that I think you misconstrued the fact that I think that of referring Ms. Ngube as the owner, you and Section 27 as the owner of the NGO.
Yeah, but in view of my argument that she in any way, whether she's the owner or the manager, whatever she is, she's not in any way responsible for a death where the personnel of the NGO might have caused the death of a person. As a quote, please, Mary.
Lady, if I could be of assistance.
Just a second. Yes, Mr. Odes.
I don't intend to reply, my lady, but what Mr. Late's referring to is at page 54792, my lady. And 54793 with dealt with this.
Page 54792.
And 54793 of his heads of argument, he dealt with the Ms. Ngube. He says even if she was the owner, he does use that term, she's not liable for the conduct of her staff.
Which paragraph? Or okay, it extends to the next page.
That falls under paragraph 6.4.3 is Ethel Jeannie Ngube. That's where he says what he says. 4.3, my lady.
I can't remember everything. I've read a lot of things there.
It's 6.4.3, my lady, at pages 547.
I've got the pages. That's fine.
That's right. Please. Thank you, my lady.
Thank you so much. Anybody else? I'm going to stop here, and I think we'll resume tomorrow morning. Thank you so much. The proceedings are therefore adjourned until tomorrow. Court pleases.
May it please the
court, pleases, my lady.
There's a court, please, my lady.
May it please the court, my lady.